Good afternoon. We're going to go ahead and get started. My name is Dan Quigley. I'm from Kirkpatrick Management Company. This is something we started a couple of years ago for the board members that work with Kirkpatrick Management Company. We have the KMC ABC, which is the association board club, and basically what we're trying to do is just get some information out there that's that you can get. We've had seminars on how to be a good board member, reserve studies, budgets. Last year, this was something we did as far as a legal panel, and it was a big hit. So we're going to try that again this year. We have moved the meetings to noon just to try and accommodate a little bit of everybody, so you can hop on there during lunchtime. It seems to work out well. We also will be sending everyone a recording of this Zoom here within the next week. Kirkpatrick Management Company is excited. We are celebrating our 50th year this year. We have got, it is Rob Kirkpatrick and his family have owned the company since the beginning. There are 8 Kirkpatricks working here every day at the office. Still very much a family business, and we're all very proud of that. We've also this year been named for the 5th year in a row as one of the top workplaces in Indiana. So it's something where we strive to give you guys good service, but also give the people that we work with all day long a positive atmosphere to work in. One of the things I am going to talk about, I'm going to turn it over to Chad here, and he's going to introduce the attorneys. Our industry is changing a little bit, and there's some issues that we're going to need to talk about. You're going to get an email from me in the next week, so keep an eye out on that. It'll probably be sent out by either come from me or come from Diane Arnett, who actually you guys have all gotten emails from before about this. The insurance industry in our business has really been at the forefront of all of our budgeting issues this year. We have seen the averages. We're getting a double-digit increases on all of our at least condominium associations and HOAs. At some point, it's in the 30 to 40% raises. We saw one of our associations we work with has almost doubled in the last year. So what we're trying to do is I'm going to get something out this year in the next week, just to kind of an idea. Just an overview of what we're seeing right now in the industry. We've talked to a couple different insurance agents, and I will get something out to you with some attached articles so that you guys can read up on it. And then I'm going to have we're going to have a kind of a emergency session more, but a KMC ABC in July, and have just talk insurance and see what we can get out there. So when we start putting budgets together for next year, we're talking about insurance. Insurance hits all during the year, so some of you might have already dealt with this. But we do want to make sure that you see that it's coming. And for some associations, they're trying some different things, raising deductibles, going with a 2% rate. If there's a roof hail claim, they're going to pay 2% of it. So just different things you need to keep in mind. So I'll be hitting you guys up with that in the next week, and then we'll have something in July for all board members to get on and ask questions and talk about. With that, I'm going to turn it over to Chad Earl. Chad Earl has been with us for over 15 years. He is a PCAM. He has been working with the company and within the industry for over 20 years and doing different things. Leah Mesmore is in her 11th year. Leah will be actually handling the chats and talking about different things. So yes, she'll have somebody helping her. It looks like Michael's going to help her over in the corner there. But we're going to get going on the thing. I'll turn it over to Chad. Chad, thank you very much.
Yeah, thank you, Dan. Thank you, everybody, for joining us this afternoon. We have 3 attorneys joining us for this webinar. Stephen Donham with Thrasher, Bushman & Vocal, Greg Chandler with Eads, Murray & Pugh, and Kelly Elmore with Kovitz, Schifrin, and Nesbitt. Each of them is going to be talking for 10 to 15 minutes. At that point, we'll open it up to chat. You can put your questions into the chat, and Leah will read the questions to the attorney, and we'll have a Q&A for 5 to 10 minutes after each attorney speaks on their given topic. Stephen Donham is going to go first. He's going to discuss how to amend your governing documents. All documents for HOAs have to allow for amending the documents, but there are certain procedures and processes in place that allow the HOA to pass or amendments. So he'll be talking about that. Greg Chandler is going to be talking about records retention. Your HOA is required to retain certain records. Certain records are required for different lengths of time, and he'll be talking about that. And then Kelly is going to be talking about annual meetings and the purpose, the process, quorum, voting, and virtual meetings, which is obviously something we've encountered in the past couple of years. With that, I'll turn it over to Stephen Donham, and he will discuss how to amend your governing documents.
Thanks, Chad. Hey, everybody, I'm Steve Donham. For those of you who don't know me, we'll jump right into it with the amendment process. I kind of like to think of it in terms of two components. We've got the content of the amendment. In other words, what language are we changing about the governing documents? And then the second part of that is the procedures for making sure that your amendment is approved correctly in accordance with your governing documents. So on the content issue, kind of the preliminary question is, well, how does a board determine when an amendment is needed? As an example, one time I had a board just say, hey, we want to amend Article 10, Section 2B of our declaration. Here's our verbiage. Let's go. And it's my job to kind of pump the brakes on that and say, well, hold on now. Are we just amending for the sake of amending our governing documents, or did we hear about another community approving an amendment? I mean, that's sort of some evidence that an amendment might be needed. But I like to kind of start with a conversation with boards and say, okay, well, what's our problem that we're trying to address, or what's our perceived problem in the community, and what evidence do we have of that? So, for instance, maybe you notice a lot of inoperable vehicles parked in driveways. Okay, that could be a problem. If we've got some potential buyers driving through the neighborhood and they see a bunch of broken down vehicles, that's probably not going to look very good. So once we've identified the problem or a perceived problem as a board, well, how do we want to address that issue? And a lot of times what I want to do is say, okay, well, we've identified the problem. What do our current governing documents say about it? Do they address that problem? Do they only partially address that problem? Because if they don't address it, then it makes sense. Okay, let's go about the process of pursuing an amendment and getting the content right to address our problem. Some boards, if they haven't had a lot of interactions with the membership about an issue and they think it might be contentious, some boards like to do a questionnaire or a non-binding poll of the members to find out, okay, are folks interested in this in the first place? The board might be interested, but are the individual members? And so if the board isn't sure, it might make sense to do a pretty easy electronic non-binding poll to find out where the membership's position is on a given topic. And that way you can avoid the expense of doing a whole bunch of mailed notices, proxies, and ultimately you have no membership support, and you've spent all that money on those hard costs for a dead issue. So, we eventually determined that, okay, there's a problem that's not addressed by the governing documents. At that point, I highly recommend working with your legal counsel to draft the amendment. Lawyers write in a particular language that will help avoid ambiguity, enforceability problems, those kinds of things. And so once you have a draft amendment that your attorney has prepared, the board approves that. And then the next phase is procedural. But there's really two components to it. One component is persuading the members to vote in favor of that proposed amendment. I mean, if the board has said, we want to offer this to the members to vote on, that means the board's in favor of it, but then they've got to sell it to the members. And so how do you do that? Well, I've seen some boards do explanatory town hall meetings to kind of go through, okay, what are we trying to accomplish with this? Because there's probably a lot of legal jargon that members are reading and maybe not understanding very well. And so town halls are a helpful way to explain that to the members. Some boards, they want to ensure that this gets approved. So they will go door to door and talk to their neighbors and about the content, what they're trying to accomplish, try to obtain proxies. That's another way to try to convince folks to vote in favor of this. I've seen other boards put together like a frequently asked questions sheet. Often I see those when there's a proposed rental restriction that's being offered to the community. Maybe I'll pause there to kind of get into, okay, what am I talking about with rental restrictions? Usually those come in two flavors, a total rental ban amendment or a rental cap. A cap being, okay, we've set forth a certain percentage or a specific number of lots that can be rented at any one time in a neighborhood. But in addition to that, you'll find that the members have a lot of questions when it comes to rental restrictions. So these frequently asked question sheets help address those. Town hall meetings help address those. I see lots of hypothetical scenarios that members want to get into. They want to talk about, well, how do grandfathering rights work for existing landlords when a rental restriction comes into place? How do hardship exceptions work if we're at our rental cap or there's a ban in place and an owner goes on military leave? Is that a hardship exception? How does that work? Those are the kinds of questions that can be addressed at town hall meetings to help gather enough support to pass your amendment. And then in addition to that, there's sort of a record keeping function when it comes to rental restrictions. You've got someone has to track the approved rentals in the community. And so there's that extra administrative effort that goes into rental restrictions in particular. So, okay, that's kind of the first of the two procedural components is getting enough support for your amendment. And then the second part is, okay, how do we actually get this thing passed? Ensure that a proper vote is taken in accordance with your governing documents. Do you have to have a meeting to vote on the proposed amendment? That's something that you'd want to review with your council to determine. Do we have to have a meeting at all? Can we do written ballots in lieu of a meeting? What do the governing documents say about that? Let's say you have to have a meeting. Okay, does your notice contain all of the required information? Your notice of a special meeting to vote on that proposed amendment? Is your notice sent enough days ahead of your meeting? What else should be included with your notice? Are you going to include a proxy form? I think I'll kind of pause on that issue, and I don't want to step on Kelly's toes because I think she's going to talk more about that stuff. But a lot of times I think people get confused between the difference between a proxy and a ballot. A proxy is just the assignment of your right as a member to cast a ballot at a meeting. It's not a ballot itself. But what could be included on a proxy when it comes to an amendment is telling your proxy holder exactly how you want to vote on that proposed amendment. But anyway, you want to work with your council to make sure your notice is right, that your proxy form complies with all statutory requirements, and that your meeting is conducted in accordance with your governing documents. And so I'll kind of stop there. I don't think I quite went over my time, Chad, so I guess I'll deal with any questions afterwards, but I'll kind of pause there because I don't want to get into Kelly's stuff.
Sure. One question I have is, do you recommend doing an amendment at a time, or if a community wants to do a rental cap, they want to clean up the developer language, they want to add other restrictions, do you recommend trying to do them all at once or trying to tackle them one at a time?
I think from a cost perspective, you're definitely going to want to try to do it all at once. I think if you think that one issue is a particularly hot button issue, you kind of weigh the pros and cons with including it with the other issues that you're trying to get past. So it can be somewhat of a case-by-case basis. I lean toward including them all at once, though. Perhaps my colleagues have a little different theory on that, but that'd be my lean at least.
Okay. And then on grandfathering with the rental cap, are you required to grandfather in existing owners, or can you simply say no rentals going forward?
I think grandfathering, there's no specific statutory requirement, but the grandfathering provisions, I include them in all of my documents because I expect that any court would say someone is grandfathered to some extent, whether you include that language or not. So let's include a recognition of it to avoid a situation where your entire rental restriction is just tossed out by the court because it's totally unreasonable. So the grandfathering provision is just a recognition of what's kind of reasonable in these circumstances. So.
Okay. Leah, did we have any questions in the chat?
Chad, I have, it's not regarding amendments, Stephen, but we'll ask the question is, can a board member send the contact names of owners to individuals who are interested in buying? This particular community has 3 vacant units. They're not up for sale, but they've been vacant for a long time. Can they legally send contact information to people who are interested in buying?
So in this hypothetical, it's a non-member that's asking for member contact information.
Right.
Can they legally do it? I don't think there's an explicit restriction against it. They're absolutely not required to do it. I suppose it's somewhat public information as far as the mailing address, because the mailing address of all the members would be something on file with the assessor's office. I wouldn't do it. I don't think there's anything that explicitly prevents it, though.
Okay, and then if an owner is grandfathered for a rental and wants to change their ownership to an LLC, is that technically a change of ownership, or is this grandfathered clause still in effect?
Yeah, it would come down to the specific language used in the rental restriction. I think you probably, and so depending on what it says, there's probably a technical argument that would be an ownership change, and that would terminate the grandfather status. Whether a court would say, you're being a little too technical and I'm not going to enforce that, perhaps.
Okay, and then Chad, do you have time for one more?
Yeah, absolutely.
Okay, can an amendment ballot include several individual amendments to be voted upon so that some might pass and others fail?
Absolutely. Yep.
Okay.
Yep. Kind of a wholesale yes or no on all amendments, or you can break it down by specific issue, particularly if you think you're going to get resistance on some of them. At least you can get some passed.
Can a grandfather status be limited to those who rented earlier than others who are recent renters?
Yeah, the grandfathering status usually comes into play. Who is a current landlord at the time the rental restriction? That's kind of our cutoff date that we're looking at. Okay.
And Chad, at this time, I don't have any others.
Okay, well, with that, I'd like to introduce Greg Chandler, and he's going to talk about record retention. If questions continue to roll in, we'll either address them after Greg is done presenting or after Kelly is done, when we have a general Q&A. Go ahead, Greg.
Thanks, Chad. Hey, everybody. My name is Greg Chandler. I'm a senior partner at the law firm Eads, Murray & Pugh, if you don't know me. I've been asked to speak about records retention and records inspection. And it's funny, when I first got into this practice about 16 years ago, here in Indiana, we had very few laws and statutes which governed associations. We had your Nonprofit Corporations Act, which applies to nonprofit corporations generally. And then there is a very bare-boned condo statute, which applies to condominium associations. We jokingly used to refer to it as the Wild West because it was sort of like a free-for-all. Nobody really knew what the laws were or what the requirements were. And in some ways that was good, some ways not so good. The landscape legally has evolved a bit since that time. The Indiana HOA Act was adopted in 2009, and that has been amended by the state legislature a number of times since 2009. Some of the changes made to the HOA Act pertain specifically to HOA records inspections and record keeping and record inspection. Namely, those laws include specific requirements that associations have to abide by in terms of both record keeping and allowing members to inspect certain records. And it's imperative that you as boards and your managers are aware of these requirements, because this is one area where associations can face potentially adverse and expensive legal consequences. So if you're not aware of the records requirements and you wrongfully deny an owner's request to inspect certain HOA records, the association can potentially get into legal trouble. So this is important stuff. I'm going to jump right in. And one thing I'd like to note at the outset is that a member of your association does not have to tell you why he or she wants to inspect certain records. And in addition to that, members can essentially request the same records over and over again. And that's a point of frustration, I know, for a lot of our clients and managers, because many of you probably have that one owner in your community that, you know, every year on the dot wants to see this financial record and that audit and that contract. And you're thinking to yourself, okay, you've seen these records how many times? Do we really have to let this owner see those same records again? Specifically written into the HOA Act as a requirement, or it states specifically that members can request records anytime they like. They do not have to tell you why they want to request those records, even if you know deep down that it's probably for not the best of intentions. As a managed association, your Kirkpatrick, I assume, probably maintains most or all of your association's records. So as far as what's kept, should be done legally by Kirkpatrick management. In fact, I have every confidence that Kirkpatrick is following the state laws as far as record keeping goes. But it is important also for you as boards to be aware of that, and also for you to discuss with your property manager some policies in terms of how you'll handle records requests as well as records inspections. So meeting minutes, for example, are to be retained as permanent records of your association. That includes all board meeting minutes as well as membership meeting minutes. It also includes records of any actions taken by the board or by the association outside of a meeting. The State Nonprofit Corporations Act states, and unless your bylaws say otherwise, that association boards, for example, or corporation boards, for example, can take action outside of a regular meeting if the members consent in writing to that action being taken. So many of you have probably adopted resolutions from time to time outside of a regular board meeting. Copies of any of those actions or resolutions would have to be kept with the corporate minutes and provided to owners upon request. Pretty much all financial records are fair game. So anything like invoices, bills, receipts, bank statements, financial statements, audits, copies of year-end financials, all of that stuff would be fair game and subject to inspection. Any executed contracts would have to be provided to the owners upon request. And note that that applies to finalized executed contracts. So like your landscape contract, your pool contract, your pond contract, any finalized executed contracts that you have as an association with outside vendors would be subject to the owner's right to inspect. Note that that includes only executed contracts. You do not have to allow members to inspect bids or emails pertaining to contract negotiations or any records at all pertaining to contract negotiations or bids or proposals submitted. Owners do not have a right to inspect that information, but if it's a final contract, owners do have a right to see a copy of that contract. Certain types of communications must be subject to inspection. So for example, any communication pertaining to an owner's property, if for instance, I'm an owner in your association and I have a right to see copies of communication pertaining to my lot. So any letters that have been sent to anyone about my lot or to me about my lot, I have a right to see those emails or letters or whatever's been provided. If there is a dispute between the owner and your association, then that owner has a right to see all records pertaining to that dispute. And then any communication initiated by the association that is sent out regarding an owner's lot must be, or property must be shared with the owner of that property. So for example, if I have the House of Horrors on the corner that everybody knows about and is being poorly maintained and hasn't been mowed in 2 years, and the siding is falling off, and the HOA board and the manager decide they want to send out something to the community about my lot to point out, what's going on and what actions are being taken, and or just to discuss my property generally, that's fine under certain circumstances, but I have to be given a copy of that correspondence. You cannot send something out to everybody except for the person to whom the correspondence pertains. So that's something to note as well. And that applies to all communication initiated by the association. So not a response to a complaint that you might send or your manager might send, but something that is coming out from the association or the managing agent. Other types of records. So your current governing documents are subject to inspection, any board resolutions and rules. Some of these, depending on how you're set up, you may have a community website that has some of this information already, that maybe your covenants and your bylaws and resolutions and rules are posted on the community website. And it's fine if you want to direct owners to that website if they're readily available, as opposed to having to schedule an in-person inspection. But pretty much all of your governing documents, your covenants, bylaws, articles of incorporation, board resolutions, rules, all that is subject to inspection as well. The membership list, you have to have a membership list setting out the names and addresses of all members of the association. Note that does not include email addresses. It does not include telephone numbers. You do not have to provide that information unless an owner has consented to that private information being sent out. But you do have to have a list that includes the names and addresses of the members, and that list is subject to inspection. Now, this is the one area where you can ask owners why they want to see the record. Owners do not have a right to use the membership list for any purpose that is not relating to the association. So I cannot request the names and addresses of all members to promote my real estate business or my law practice or to solicit donations. It has to be for a purpose pertaining to the association. So this is the one record where you can actually ask the owner, why do you want to see it? And you can make sure that it's for a good faith purpose related to the association. There are some exclusions which are to be noted. The most important exclusion of which you need to be aware is that owners do not have a right to see records which go back any further than 2 years. You only have to go back 2 years. So I can't come to you and say, I want to see all records going back to the beginning of the association or all financial statements for the last 10 years. I only have a right to see 2 years worth of records. So it's 2 years from the date the request is received. Any unexecuted contracts, I hit on bids and proposals earlier. Owners do not have a right to see any bids that have been submitted or proposals that have been submitted. It's only finalized contracts. Any information about someone else's account. So delinquency information generally is considered private in nature. I do not have a right to see Steve Donham's or Kelly Elmore's account to find out how much money they owe the association. You do not have to provide that information. So anything pertaining to a specific owner's account or their assessment information or otherwise does not need to be provided. The statute includes a general exclusion for any information prohibited from release under the law. So there may be certain types of records or correspondence that would be deemed confidential in nature that you would not have to provide. Any type of attorney-client communication should not be provided and cannot be provided. That's not subject to disclosure. And I want to stop for a minute and emphasize that you should never, ever, please never send out any type of attorney-client communication to the members unless you have first discuss that with the attorney, with the association's attorney, and for whatever reason the attorney has advised that under those circumstances it makes sense to do so, which there aren't too many circumstances I can think of where it would ever make sense. Once you have disclosed attorney-client communication, you have waived attorney-client privilege as to that issue. And that can have devastating consequences if you end up in court with somebody in litigation. If you've waived attorney-client privilege as to certain types of communication, that can be used against you. So you want to take that very seriously. Please never send out if it's an attorney opinion letter or an email that's come from our office or Steve's office or Kelly's office, please do not post that do not post that on the website. Do not send that out to the owners unless you have first discussed that with the association's counsel. And then finally, any information provided by a member about another member which involves suspected criminal activity, that is excluded as well. So if Steve Donham submits a request or information to the board or the manager stating that he thinks I'm cooking meth in my bathtub, I'm not, I swear, but that Steve's communication is confidential in nature because it pertains to a suspected crime or criminal activity for good reason. All requests from the owners must be in writing, and they must clearly state what it is the owner wants to see. I cannot come to the board or the manager and say, I want to see all HOA records, or, I want to see all financials. Well, what do you mean by financial? What do you mean by records? I have to specifically tell you what types of records I want to see, i.e. the audit from 2020, or the year-end financials for 2021, or the ABC landscape contract. I have to specifically tell you. I mean, I see owners all the time that send these broad general requests, and I want to see all records or all financials. Well, we can pin the owner down as to what he or she actually wants to see. As far as inspections are concerned, this may vary depending on the circumstances and what's being requested, and perhaps to some extent who is making the request. As a general rule, I recommend that inspections be conducted in person. Owners have a right to inspect records. You're not obligated to send out emails or mail the records. You can ask that the owner come into the offices of Kirkpatrick Management or another location and inspect the records in person in a conference room. And in most cases, I think it makes sense to do it that way. What I've seen over the years is sometimes owners will request information that they want to weaponize against the association. So they'll request financial records or contracts or whatever and want to put their own spin on it. So if you send those records to somebody, if it's your community troublemaker, for example, by email, you make it very easy for that owner to simply post it on his or her own website or mass forward to, God knows how many people. Now, theoretically, hypothetically, they can do that anyway if they get copies of those records, but you make it a lot easier for somebody to use those records against you if you send it out in an email form. So more times than not, I think it makes sense to make them set up a time to come into Kirkpatrick's offices, sit down at a conference table, look at the records in person, and then if they want to make copies, they can do so at their expense. And that may, again, vary depending on the request and who the owner is. If it's a one-off and just one document and it's the request is being received from somebody who's not a troublemaker, then maybe, you send the minutes to that one owner by email, and, maybe that's a bit more efficient than making them come into Kirkpatrick's offices to inspect in person. And that may depend on the board and discussion with your manager, but I think in most cases, an in-person inspection is probably best. You do have a right to charge owners for any time spent gathering records. So if you receive an especially voluminous request from an owner, you have a right to charge up to $35 an hour for all time spent gathering those records and locating those records. The first hour must be free. And then after that, you can charge $35 an hour up to a maximum charge of $200. And the last point I want to hit on is maybe the most important point. The Attorney General's office has limited jurisdiction over homeowners associations, and it's very limited by statute. There's only so many things that, so many issues that the AG's office can regulate when it comes to associations. But one of those areas is records inspection. If an association is found to violate or to not comply with the law when an owner makes a request to see certain records, let's say that I come to you and I want to see the landscape contract for the last 2 years, and for whatever reason, the board or the manager says, well, no, you don't have a right to see that. Well, technically, that's a violation of the HOA Act. And under the HOA Act, it specifically sets out certain actions that the Attorney General's office can take against the association. That includes potentially filing a lawsuit against the association. The Attorney General's office has a right to sanction associations up to $500 per violation. And while I've not seen the Attorney General's office, look at it this way, hypothetically, I think they could probably construe each record as a violation. So you're actually looking at, if it's a voluminous request, perhaps $500 times 5, 10, or 15, if it was a large request. Again, I've not seen the Attorney General's office, take that kind of action. Hypothetically, if given the right set of circumstances, I think they could do so. So the long story short, your board, your manager, you must be aware of these requirements. Potentially the legal consequences could be severe and expensive. And with that, I will conclude my comments and address any questions if there are any.
Thank you, Greg. I know we have a handful of questions. Leah?
Kind of jump back to Stephen's, a couple came in after is one question. What is the definition for property abandonment?
The definition for property abandonment. That suggests to me that the question is geared around whether a lot is vacant or not, whether it's occupied. I probably would need a little more context to weigh in on that, but it sounds to me like what we're getting at is a vacant lot.
Okay. And I don't know if you know the answer to this, but what is the percentage of rentals when a mortgage company will not loan for the purchase?
Oh, geez, I just looked at the other day. Is that, Greg, help me, is that 50%?
Yeah, it's been a moving target. I think last check it is 50%. I know for a time it was 25%, but my last recollection, the last time I looked at it, I believe it was 50%.
Yeah,
Okay.
that's my too. Leah, I can get a specific answer. I just haven't looked at what HUD is saying about it these days, so I can get that to you.
Okay. Can a resident recommend an amendment, or does it have to come through the board, the amendment?
That's a great question. While normally they come from the board, there is a process likely in the governing documents, but definitely in the nonprofit statute that allows a member to call their own special meeting if they get a certain percentage. Under the nonprofit statute, you need 10% of your members to petition for a special meeting. And so they could pitch a proposed amendment if they get enough signatures to call a special meeting. And there's a whole bunch of procedures for that under the nonprofit statute. But no, it does not have to initiate with the board.
Okay.
And if I could just add, the question then becomes, okay, if 10% of the membership petition for a special meeting to address a proposed amendment, the board has the option to still run that meeting. And like I said, there's some procedures in the statute about that. I like to have the board still kind of take the reins and run the meeting, even though they're not the proponents necessarily of the proposed amendment.
Okay. Greg, a question came up. What about emails between board members versus all owners? Can homeowners see that? And then kind of a question into that as well. If we email a lot, can they request emails from our personal email systems? For example, if I communicate about an issue to other board members or Kirkpatrick, can they request those emails?
Okay, so yeah, I mean, that's going to depend on a few different factors, and it's going to depend on what exactly is being requested. So the act states that I, as an owner, have a right to request copies of communication that pertain to my lot. So, for example, if there's if there are emails floating around between, say Kirkpatrick or among the board that do not involve legal counsel, then that's probably something that you would have to provide to me as the owner request, because it pertains to my lot, or if it pertains to a dispute that I have with the association. And as a general rule, you want to be very careful what you put into an email, and even leaving the HOA Act aside, you should always assume that anything you put in writing could come out in court one day. Besides the HOA Act requirements, if you end up in litigation with somebody, there's a process called discovery where both sides have a right to request documents from the other side. So potentially you may have to give up some of those emails anyway, even if it's not something that would fall under the HOA Act requirements. But generally speaking, there's not confidentiality for emails that are floating around, among the board. So if it's communication that pertains to my specific lot, then that's something that you would have to provide in most cases.
Okay, Chad, I know this could be a long list, but just some highlights. A question came up. What are the records KMC keeps for HOAs?
So that's going to be dictated in the Retention Act, right, Greg? It specifically states what we have to keep.
Correct. Yeah. So the Nonprofit Act and HOA Act sets for certain records that the HOA has to keep. Yeah, for the most part, those are the records that I refer to. So your corporate minutes, your resolutions, your governing documents, your contracts, financial records.
And we can provide that list to any board member who wants to look at that. But at this time, we've kind of hit our limit with Greg. We're going to move on to Kelly, and she's going to talk about annual meetings.
All right. Well, thank you so much, Chad. Again, I'm Kelly Elmore. I'm the managing partner for the Indianapolis office of Kovach Schiffer Nesbitt, or KSN, and I'll be jumping into annual meetings. Typically, this is about an hour presentation, so I'm going to just kind of run through and hit the highlights really quick as we breeze through this. So going through, first of all, purpose and components of the annual meetings. I think sometimes certain owners and even sometimes board members are not aware of the specific purpose of an annual meeting, certainly to first and foremost elect your directors, but also for many associations, it's also the time to approve the annual budget. It also generally is an opportunity for the board to share and report on activities and financial results of the association during the past year. I know a lot of times boards will take the opportunity because a lot of owners throughout the year do not attend meetings. They'll share reports, things they have investigated or looked into over the year, any reports on major projects, and just a great opportunity to share information with the ownership, as generally those meetings are better attended than your general board meetings. In addition, the annual meeting might also be the meeting where your association is voting on issues requiring owner approval. So for some associations, if you have an amendment to approve, you might be setting up a separate owner meeting for that amendment approval. And I know some associations, if the annual meeting is coming up, they'll take that opportunity to use the annual meeting to adopt the amendment or to conduct the vote. Moving into quorum. So this has certainly been a huge issue with many of our associations over the years as far as achieving quorum. And for those who might be unfamiliar with the quorum terminology, quorum really just refers to the minimum amount of owners needed in order to proceed with a meeting. So you can have quorum for board meetings, you can have quorum for owner meetings, and it's generally set forth in your governing documents, in your bylaws. It could be elsewhere, but it's generally found in that particular document. Fortunately, under the law, the quorum can be achieved not only by an owner attending in person, but also by proxy. So many of you are probably familiar with, as you are conducting votes or in your annual meeting for your board election, the association will distribute a proxy for voting purposes. Owners who cannot attend, or even who might be planning on attending but want to make sure their vote is registered with the association, may submit the proxy in advance for the meeting. So the quorum can be achieved either in person or by proxy, and then any other means allowed either under state law or your governing documents. So over the past several years, well, in decades really, we've had a number of associations who have come to us, and I know Greg and Stephen have probably faced quite a few of the same complaints with boards about failing to achieve quorum. And it has been such a huge issue that Many of us in the industry are now working on legislation to actually address the minimum quorum requirement for association meetings in Indiana associations. We are working to propose legislation that will actually streamline that minimum quorum requirement. There are some associations who have incredibly high quorum thresholds, like 51%, just to allow a meeting to proceed. So we are working on hopefully coming up with a uniform quorum percentage that's a lot more reasonable, that will allow associations to function and administer the association much more efficiently. There are, however, in the meantime, for post-June 2009 associations in Indiana, there were allowances in the HOA Act that were adopted, and now allow a board, if you don't adopt, if you don't achieve quorum, that the board may adopt the annual budget subject to certain limitations. So depending on what the amount is for your budget, you might be capped at 100%. If your governing documents allow, you might be able to go up to 110%. So you just need to consult with your attorney as to what your particular governing documents allow. And again, it also depends on if you are a post-June 2009 association. So additional comments on quorum. There was also a provision that was added to the HOA Act to allow some, I guess I'll call it concessions with respect to the running of an association, particularly with the board terms, when quorum is not able to be achieved at the annual meeting. So we had, I've had a number of associations report that they've not been able to achieve quorum last year, the year before that. And every so often, there will be challenges from the ownership as to whether or not the current board that is still seated is actually a legitimate and valid board of directors. And the HOA Act is very clear on this issue, that members of the board may continue to serve until their successors are elected or appointed. The HOA Act also confirms that owners are continue to be obligated to adhere to the provisions of the governing documents. Again, despite the failure to achieve quorum for an annual meeting and to be able to proceed with a board election. And finally, the Act also confirms that the board continues to have the authority to enforce the provisions of the governing documents. So I've certainly seen challenges over the last 2 decades with respect to owners who claim, I don't think this is a validly constituted board, therefore I don't need to pay my assessments. I don't agree with this budget. I don't agree that this board, which has been around for a while, has the ability to continue to run our association or enforce our documents. And the law is very clear on that issue. So going into voting itself, as Stephen mentioned, there is a distinction between ballots and proxies. So typically when you are voting in your annual meeting, the association is distributing a packet, notice of your meeting, and potentially a proxy for owners to submit in advance of the meeting in the form of a proxy. As Stephen mentioned, the proxy is not a ballot. And I think that is one of probably the most commonly confused aspects in our industry with respect to voting. The proxy is nothing more than a directive giving someone else the right to vote on your behalf. That individual then can appear for the meeting. And sometimes, often it's designated even just another board member. And that individual is then designated to have the right to cast the ballot on your behalf. It can be a general or a limited scope authorization. So with respect to the annual meeting issue, it might, one, give the proxy holder the ability to certainly vote for candidates in the board election and also give the proxy holder the ability to cast your vote on behalf of the budget issue. And then as Stephen mentioned, other types of proxies that you're typically used to seeing in associations are proxies for voting on amendments or other association issues. Finally, with respect to the voting, electronic voting and voting by electronic means. So I really draw a distinction between those two terms. So electronic voting is typically the term we use when an association is using like a third-party platform. There are a number of national companies who actually set up voting websites and voting mechanisms for associations, kind of streamline the whole process. They upload your voting documents, owners receive an email, and you can submit your votes online, versus submitting votes via electronic means. And that is allowed in Indiana under the HOA Act, which allows owners to submit proxies to the association via email or other type of electronic means. So I think I saw one question asking about electronic voting or email voting that is permitted in associations. Lastly, one of the more recent topics we talked about certainly over the last few years is actually the concept of the virtual meetings, which now, 3 years ago really weren't done at all. And then after the pandemic or during the pandemic, many associations moved to a virtual meeting format. And now we're seeing quite a few associations doing the hybrid meeting format. And the hybrid meeting format is what I refer to as you might be still allowing a physical location for your meeting, but also allowing owners who wish to appear via Zoom or WebEx or some other online platform. You're creating the dual approach to allow for those owners who still want to appear in person, but also create an opportunity for those owners who can't attend in person to appear via virtual means. To date, there is no express legislation on that issue. That is also something that we, and when I say we, many of us, including Greg and Stephen's companies, were all very involved with CAI, the Community Association Institute. And one of the things that we are working on with our Legislative Action Committee is creating legislation, as I mentioned previously, to address things like quorum, but also to expressly allow for the usage of virtual meetings in homeowner and condominium associations in Indiana. So, over the past several years, what we have heard from a lot of board members is there were, for various reasons, including security, safety, just ease and convenience, a lot of board members really loved the opportunity to be able to host meetings and to allow more owners to participate because of the virtual meeting platform. And we've sort of been in a gray area as far as what we have been advising associations that they can do, and we want to make it crystal clear that associations, it is allowable to conduct these meetings. If your association chooses, it might be a situation where your governing documents will need to allow for it, but we are working on addressing that via legislation so that it applies to all associations. Over the past few years, other benefits that we have heard from managers and board members on being able to conduct meetings like the annual meetings virtually, certainly reducing the cost of renting a meeting space for those associations who don't have a large community space, not needing to provide hard copies of materials. So it's a lot of printing and copying when you have your annual meetings and your voting packets. And also, I think sometimes it's allowed owners to sort of streamline the meetings themselves, because one person can speak at a time, people can record the meeting, much more easily in a virtual format. So with that, I will turn it over to Chad or Leah for any questions. Oh, you're muted, Jim.
I'll go ahead and start. Please clarify your definition for electronic voting and voting by electronic means. Do they apply to proxies only?
So the voting by electronic means is the term that I use when we're talking about submitting a proxy form via email. Other electronic means, maybe you're in the virtual meeting and you're submitting the proxy to the association over that format, because there's ability over Zoom and WebEx to submit proxies electronically. Under the HOA Act, it says that proxies can be submitted via email or other electronic means. Versus electronic voting, what I was referring to are those third-party platforms. I'm trying to think of some of the name of the companies that tailor to community associations and actually create an electronic or on-site website format for submission of votes.
Okay, is there an Indiana code regarding a budget? Our documents do not require a vote unless increase is beyond a certain percentage.
So depending on the year of your association, whether you are pre or post June 2009, I think I mentioned there's a section about the approval of the budget if you don't achieve quorum. With respect to just is the question more about whether or not the board's approving it or the owners are approving it?
I think the owners.
Oh, okay. So pre-2009, your governing documents might provide either the owners are approving it, the board is approving it. And if it does not require a vote, then generally the vote is not required.
A board uses Trello to keep an organization of their projects. Can an owner also request to see the Trello, just like they would request to see an email?
And Trello is what?
It's an organizational software.
Oh, so is the question whether or not that falls under the records request?
Yeah.
I think, well, as Greg outlined, so the HOA Act and the Condo Act, they're very clear as to what documents you can request. And as Greg mentioned, it only goes back 2 years. Now, I will say I would definitely also look to see if your bylaws or your governing documents have any other further requirements as far as the production of documents. If the records maintained on a third-party platform fall under one of those classes of documents, they might be subject to production. But if they don't, then they would not.
I think, Kelly, this is good to bring up because you can mention what is coming up with CAI. The question came, Kelly mentioned quorum legislation being worked on. Can you tell us some other HOA related lobbying efforts happening?
Yeah, absolutely. So our committee has been extremely active these past 6 months. And there is a legislative update event happening on June 21st. It's going to be at Launch Fishers. If you go to the CAI Central Indiana website, you can register. We are going to have representatives there, as well as the chief counsel from the Attorney General's office. So I know Greg was talking about the Attorney General complaints, the scope of what they can and can't review. They're going to be there talking about from their perspective when they get these complaints, what they're doing with them, what they're looking for, things like that. And then the legislation that we are working on collectively as a group, it is intended to address the quorum issues, electronic voting, electronic or virtual meetings, also potentially even streamlining how the collection process runs. I know I've had a lot of discussions with Greg's colleague, Kim Sutter, our board president, about, how can we better, make it a better process for associations to be able to collect not just assessments, but also other debt that accrues. And certainly one of our biggest issues we are tackling is the ability of associations to impose a fine for violations. So instead of forcing associations to always have to go through costly litigation, we're trying to make it much more clear on the ability of HOAs to assess a fine.
Okay. With a third party providing the voting, would it be in the form of a survey including the owner's position? Like how they voted?
I think it's it depends on the third party platform. So I know there's a ton out there. I'm sure Kirkpatrick gets bombarded with vendors offering their services. I think you have the ability as an association, you work with your manager and you tailor the voting materials to what you want them to do.
Okay.
Thank you.
Chad or Leah, you have more info on that.
Yeah, I'd like to thank Greg, Stephen, and Kelly for volunteering their time. It looks like we've hit an hour. If we did not get to your question, we will be answering those questions and emailing them out to all participants. I'd like to thank everybody who joined today. We value you as customers, and hopefully we'll see you at the next one.